Welcome back to another intense courtroom breakdown. And today's case is one that has everything: legal drama, emotional testimony, and a defendant fighting for a second chance. The case you're about to watch is State of Texas versus Diana. Lacante, a possession of a controlled substance charge carrying serious consequences. Up to 10 years in prison and a $10,000 fine. Now, right from the start, we get a glimpse of the human side of the courtroom. The judge is joking about how to pronounce the defendant's last name, Lacante versus Lacante. On the surface, it feels lighthearted, but don't be fooled. This is the calm before the storm. Here's the setup. Diana is facing a felony charge. But instead of heading straight toward prison time, the court is weighing something called deferred adjudication, a legal arrangement where guilt is technically withheld if the defendant completes probation successfully. If she slips up, though, that deferred adjudication vanishes, and she could be sentenced to the full term. High stakes. Throughout this case, we'll see legal procedures unfold step by step. Plea bargains, courtroom admonishments, and even a very personal testimony about Diana's struggles in an abusive relationship. The question at the heart of today's hearing: does she deserve leniency, or should she face the full weight of the law? Stay locked in, because the tension builds, and the judge has a few surprises when it comes to sentencing. But before we dive in, what do you think? Should courts lean toward rehabilitation and second chances? Or do tough crimes always demand tough punishment? Drop your thoughts in the comments below. We'll revisit that question when we see the final ruling.
I think that's an opportunity.
Yes. All right, the court is calling 2025 CR 004180, State versus Diana Lacante. Could I have parties announced?
Rick Pena for the state of Texas.
Nick Aguilar on behalf of Your Honorable Diana Lacante.
And how do you pronounce your last name? Lacante. All right, all right, you're not Jordan? She's not from Louisiana, okay.
Well, she says she is.
Oh, yeah.
It's not the correct pronunciation. What is your family doing?
He's over there.
Mom. Come on, Mom. Teach you have to teach. Oh, no, don't come forward. Yeah. You got to teach your daughter better with the pronunciations. No. Yeah, let me just tell you. We're off the record.
How should I pronounce it from now on?
Put that accent over that E.
All right, so
We're back on the record. Counsel, have you received all the discovery in this case?
Yes, Your Honor.
And did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. And is there an application in this case?
Yes, Your Honor. This should be up there. I'm down in my notes.
All right. Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
yes,
Did you review the true bill of indictment with your attorney? Did you understand it?
yes,
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State you're proceeding on the indictment as presented, correct?
Yes, Your Honor.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand your charge of possession of a controlled substance, penalty group 1 gram to 4 grams as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with, why are you putting citizenship Louisiana on this paper?
I always do that, Judge, just so the judge knows I ask. Always put.
Let's pause here. The judge is making something very clear. Deferred adjudication isn't a free pass. If Diana violates probation, the court won't just restart. It can immediately impose a prison sentence of up to 10 years. Think about that. One mistake, one failed drug test, one slip back into old habits, and she loses everything. This is the kind of legal setup that forces defendants to walk a razor-thin line. Now, here's a question for you. Would this motivate you to stay, clean and follow the rules? Or do you think the pressure could backfire, making success even harder?
Stay.
Okay, all right.
When you see that, you'll see it on all my, I always make a note there so they know I passed.
Oh, okay. I was like, are you just doing that?
Another country. Lafayette.
Lafayette, okay.
You know where that's at.
All right. Did you understand by entering this plea, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Very much so, yes.
Do you believe she's currently competent and is legally sane at the time of the offense?
Yes, Judge.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? Okay. According to the plea, punishment is to be assessed at a $2,000 fine. The state is recommending deferred adjudication, and there's to be restitution for drug testing. Did you understand that to be the plea?
Maybe.
Oh, well, let me go over it. So, according to your plea bargain agreement, there's a $2,000 fine.
Yes.
The state is recommending that you be placed on a form of probation that's called deferred adjudication. Did you understand that?
Yes.
And they're asking for restitution, and the restitution is supposed to be for the drug testing. Do you understand?
Yes.
They don't have an amount for the drug testing because it's not in the police report how much it costs to test the drugs. Do you understand that to be your plea?
Yes.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney?
Here's where things get very real. The plea bargain is officially laid out. A $2,000 fine, probation through deferred adjudication, and restitution for drug testing. Notice how the state doesn't even have an exact dollar amount yet for those lab fees. This happens often. Defendants agree to restitution costs without knowing the final total. So we have the legal framework: probation instead of prison. But the real question now becomes, will Diana be able to hold up her end of the e-four deal? Let's keep watching as her defense attorney starts painting a fuller picture of her struggles.
Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, were there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and 150 hours of community service restitution. Did you understand that was a recommendation from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. At this time, state I present evidence, State Exhibit 1 with all attachments.
All right, state, you may be excused.
Thank you, Your Honor.
Judge, we have no.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Oh, shit. Here we go again. Worst place in...
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. All right, proceeding with sentencing.
If you would consider that this afternoon, Judge, yes.
All right, anything you wish to say on behalf of your client?
Judge, Diana was in an abusive relationship. She admits that she did one of the drugs in her stock. She tells me she was self-medicating to help her through the relationship she was in. If you've never been in trouble before, I'm aware of. So it took a bit to get through to understand the deferred concept, or deferred adjudication.
This is one of the most emotional pivots in the entire case. Diana's attorney brings up her abusive relationship, explaining that her drug use was essentially self-medication to cope with trauma. For first-time offenders, especially those with a history of abuse, this context can make a huge difference in sentencing. But let's be honest, this raises a tough debate. Should personal struggles and past abuse reduce accountability in drug cases? Or should the law stay firm regardless of circumstances? What do you think? Would you give her a second chance here?
But she would like you to consider granting her the deferred adjudication for a period of 4 weeks.
All right, are you employed?
Yes.
What do you do?
I'm a sales agent.
And what are you selling?
Spectrum. Spectrum.
Spectrum.
Spectrum. Okay. Spectrum does keep going up on their prices. Nobody knows. They get you in with the contract and then prices rise. So I've heard. How long you been working there?
I just started my 4th week.
The last time we were here in Florida, we got out of here quick so that you could get her orientation done.
All right. And how many children do you have?
3,
What are their ages?
25, 22, and 17.
All right. And do they still live with you?
No,
Okay. Where's the 17-year-old? Who's he with?
he's with his dad.
And if you're drug tested today, what are the results going to be?
I'm pass.
Hmm?
I'll pass.
When's the last time you used?
4/20, 2024.
Okay. All right. This is what the court is going to do. There's a $2,000 fine that will be probated. 4 years deferred adjudication. 150.
And here's the twist. The judge decides to add parenting classes on top of probation. Even though Diana's kids are almost grown, the court emphasizes the value of learning parenting skills as part of rehabilitation. In fact, the judge sweetens the deal. If she completes the classes, those 150 hours of community service will be waived. This is fascinating because it shows how much discretion judges really have. Instead of punishment for punishment's sake, this judge is shaping probation into something more practical, more rehabilitative. It's not just about serving time, it's about growth. Honestly, this is where the courtroom feels less like a punishment chamber and more like a second chance machine.
Hours of community service restitution. And you know what? Even though he's 17, I'm going to ask for the parenting classes. You can never go wrong with the parenting class. Once you complete the parenting classes, the 150 hours of community service restitution will be deemed satisfied. Now, if you don't want the parenting classes, your other option is to work in the Texas heat for 150 hours.
I don't mind classes either.
Okay. So there has to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. Do you have to go to work today?
Oh, yes.
Okay. Then we'll do a UA tomorrow. There'll be field visits 1 time per month for 4 months. TAP evaluation, out of custody, follow TAP recommendations. If TAP recommends inpatient treatment, we can start with intensive outpatient treatment.
I did all that. No, I did
Hmm.
Patient, I did outpatient. I
Oh,
said-
just give that information to them. Okay, but what the CAP evaluation is, it's just some questions you need to answer and they'll make a decision. They may say you don't need anything, all right? All right, probation, is there anything else? Is there anything else you need from the court in order to be successful?
Just a question, if I can take the UA today, that way I don't have to miss tomorrow too.
Sure, you can take a UA today. All right, anything else?
Will somebody give her guidance on where to take that?
Yes. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I understand.
All right, we can go off the record. In this court, communication is key to be successful on probation. If you have an issue, let your probation officer know. If you feel they're not addressing it, you can always come back to the court. All right? All right, good luck to you.
Thank you so
All right,
much.
you're welcome.
Thank you.
All right, bye-bye. Mick, you were great. As far as the testing,
I think I'm gonna be fine today.
yes,
Thank you, Judge.
you're welcome.
So what was the proper pronunciation?
Let me just tell you.
And that's the conclusion of State versus Diana Lacante. To recap, Diana pled guilty to possession of a controlled substance, but instead of heading to prison, she walked away with deferred adjudication, 4 years of probation, a $2,000 fine, parenting classes, drug testing, and community service. If she succeeds, this conviction won't stain her record permanently. If she fails, though, she risks up to a decade behind bars. This case highlights the delicate balance courts face every day, protecting society while giving individuals a chance to change. Was the judge too lenient? Or was this exactly the kind of structured mercy the justice system needs? If you found this case as shocking and thought-provoking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Was put the state, sometimes the city, we saw it.
Yeah.
That way they look out and know I asked.
Yeah, because let me just tell you, that is always, that's the first time I've seen that. So that's why I was like, LA, what?
We put it there just so that they can look to say, okay, you talked about it.
Mm-hmm.
Thank you, Judge.
All right, thanks. Have a good one. Yes. I don't know. I'll have to look and see. Yeah, just give me a moment.